Let's say you're with someone you've chosen to build a life with. All the ingredients are there for a long and successful committed relationship. A shared vision of the future, shared values and beliefs, common interests, compatibility. There's love, trust, affection, intimacy, and desire. And you have a healthy and frequent sex life that runs the gamut of expressiveness. Loving sex, quickie sex, angry sex, makeup sex, drunk sex. You even have Tuesday sex. But what happens if one day your partner is injured through no fault of their own, and that life you've been living is taken away either temporarily or permanently? Well, your partner may have a personal injury claim to make against the person who caused them harm, but what about you? Hi, I'm Dave Buckley, and I'm a personal injury attorney, and I'm talking about loss of consortium, a legal cause of action used to describe a claim made in a personal injury case by the spouse of the person that was injured. The spouse's loss of consortium claim says that the injury caused to their loved one by the carelessness and negligence of someone else has also affected them, which includes, among other things, their sex life. And that they too, the spouse of the injured person, or perhaps the now deceased person, can make a claim for money damages because the quality of their life has been affected as well, that they have been harmed. When a person suffers a significant injury, whether the injury is temporary or permanent, that injured person is going to be out of commission. And if they're married, their spouse is going to be the one to look after them and encourage them and get them to their appointments and clean up after them. And worst of all, put up with their bad moods. And believe me, injured people are cranky people. But the focus tends to be on the person who got hurt. The conversation is always, how is John doing? How is Alice doing? It's never, how are you doing? The person whose own life has been put on hold and turned upside down because of someone who was texting and driving, or someone just didn't care enough to fix a dangerous condition on their property, or the doctor that performed the surgery on your spouse just wasn't at their best that day. When the negligence and carelessness of someone else injures your spouse to a point of causing them prolonged incapacity, requiring long-term care that impacts your life, that alters your day-to-day, that changes you from the person you used to be to that of a caretaker, or if your spouse is killed and you have forever lost what once was, that's when a loss of consortium claim comes into play as a legal cause of action. That's when you get to say that your spouse isn't the only one to be hurt by these unwelcome circumstances. Loss of consortium isn't only about the loss of sex and those very special moments. It's a loss that's bigger than that. It's also about the loss of society, that bond between the two of you. It's the loss of your own independence and the loss of what used to be and what may never be again. A loss of consortium claim makes the case about you, the innocent spouse, the one performing the necessary tasks for your loved one every single day. All the while, you're hoping and praying things will get back to normal sooner than later. Remember, once upon a time, there were date nights, flirtations, suggestive glances, and spontaneity. There was passion and love. These are the common activities that couples share. Perhaps it's even how the two of you met, instant chemistry. But these emotions and feelings and longings, the things that used to be, are now a fading memory, replaced by the stark reality of what your life has become. And while taking care of an injured spouse is a role you are always willing to perform because that's what spouses do, right? The unconditional love, for better or for worse. You were never prepared for how hard and demanding and lonely it would be. You weren't prepared for the fights and the tears, the despair, the sleepless nights, and the uncertainty that the injury to your loved one has caused to your relationship and to the quality of your own life. Not to mention the decimation of your finances. You weren't ever sure you'd get through it unharmed. Maybe you haven't. If your spouse has ever been injured through no fault of their own, to a point of requiring long-term care, and your role as a spouse has been reduced to that of a caretaker, then your spouse isn't the only one who's been harmed. You've been injured too. Your quality of life has been affected and changed. A loss of consortium count and a personal injury claim gives the spouse of the injured person their own cause of action. It goes to prove that you have been harmed too by the carelessness and negligence of someone else. You get to tell the story from your own perspective and how you have been harmed. And because you've been harmed, you get to demand that you be compensated for your own loss and for your own pain and suffering. Now, you might be thinking, okay, So I can bring my own cause of action for the harm that my spouse's injury has caused me. But am I going to have to make my sex life public? Do I have to tell the judge and jury how often we have sex? Give the details? I'm not doing that. No, thank you. That's just too embarrassing. Well, yes, you will. And yes, it can be embarrassing. And that's why loss of consortium is a cause of action that is often alleged in a lawsuit, but one that is just not as often followed through to conclusion, precisely because testimony has to be given on the record, in a courtroom, in front of a judge, in front of the jury, in front of the people sitting in the courtroom. And that terrifies people to a point where the loss of consortium claim is either dropped altogether or a settlement is reached for a fraction of what the claim is worth, just to avoid having to talk about the subject. And the insurance companies know this too. That's why they offer so little, if anything at all. But it's my job as a lawyer to convince you not to give in. Here's why. Making a loss of consortium claim identifies a second injured person in your household. And that makes you eligible to make your own claim for the harm caused. Why is this important? Well, because if the injury occurred to the primary wage earner in the family, and that income is no longer coming into the household, having the opportunity to make a second claim for money damages, possibly even doubling the recovery, will ease the financial crisis a family often faces following a significant injury. It's another source of funds to bring into your family, a family that is desperately in need of being made financially whole. An experienced attorney can help you approach this type of claim in the best way, in the most appropriate way, in a way that is least embarrassing to you. When telling a spouse's story to a jury, I make sure that what I'm saying to them is believable, that it's relatable, that it tugs at their heartstrings. Chances are the members of the jury are people who have been in relationships, people who are married and people who have been married, people who understand that couples have common interests and that they do things together and that they go places together. And yes, they even have sex. So when an injury that gets thrust into a couple's life unnaturally and creates instability in that relationship, the jury not only wants to hear how that relationship has been affected, but they also want to compensate you for what's been taken. But they can only do that if they have the details and if the story is compelling and if the story is relatable and if the story is believable. So when you say that before your spouse was injured, you as an individual were active and independent, and that you exercised at the gym, and that both of you occasionally went out to dinner, and that you socialized with friends, and that you took vacations if it was affordable, and that you were intimate every now and then when the moment arose, but all of that changed when your spouse was injured through no fault of their own, that's believable. That's relatable. A jury is going to eat that up because that's a life they know and understand and most likely live themselves. Being able to tell your story requires having the facts. Keeping a daily journal is the best way to memorialize how you are feeling in real times. A person making a loss of consortium claim will certainly know how life was before the injury, and that's easy to write down, but it's the post-injury day-to-day that's important. How your normal routine has been affected. What is the frequency of your intimacy now, if at all? How has your spouse's injury affected your own employment? How has it affected the day-to-day relationship with your spouse? What happened to your independence? How about your own mental health? Have you become alcohol dependent or dependent on other substances? Has your spouse become alcohol or drug dependent? And if so, you're dealing with that now too. Your story can only be told if you're brave enough to tell it. And if you do, the jury or the insurance adjuster will give your harm the value it deserves because they have been made aware of the extent of the harm caused. You only have one opportunity to make a personal injury claim. Don't let the fear of embarrassment prevent you from putting the world on notice that your world has been changed through no fault of your own and that you demand justice. I'm Dave Buckley. I'm a personal injury attorney. I hope your spouse was never injured to a point where your life has been affected and you have to make a loss of consortium claim. But I'm here if you do. I have lots of other videos on personal injury and a free ebook, so check those out. Thanks for watching.